Soji thing, which was done. Then on the 18th of May, they gave a decision on that, and that came against Pakistan. What are your views on that? What do you hear about that in the media from experts? If you will.
19 मई तक यादव के पास अपील का राइट था जजमेंट के लिए.
Now the issue was बिल्कुल इस लेवल sorry बिल्कुल राइट था.
तो इससे पहले अगर हम ये सबमिट करवा देते कि यादव ने अपील कर ली है तो क्या ये डिसीजन चेंज नहीं हो जाता?
Isliye the thing that we were not able to clarify to them was that he has multiple appeals left, and some of the appeals is simply no time limit that you can impose. Is stage पे to get preliminary measures you have to show urgency. This आपने mentioned किया, right? My assessment was that it is very difficult for India to show urgency because process का time limit ही नहीं है. There's no date जिसमें लिखा इस दिन को हम इसको फांसी देंगे, right? Had that been the case, so if we had perhaps better argued this case, we could have said, look, he has now an appeal to the chief. उसके बाद he has a mercy petition to the chief. उसके बाद he has a mercy petition to the president of Pakistan, federal government, president of Pakistan. So outside of the military system, he also has another mercy petition. उसके बाद he can do writ jurisdiction 199 के नीचे.
What did we argue then?
So what we said these things, but we said it in a convoluted way. We didn't give time limits. There are time. Pakistan Army Act is a very specific time limit. Itne days में you have to. So what we could demonstrate was कि इसको कम से कम फांसी 3 महीनों में या 6 महीने ऐसे कुछ थे उसमें नहीं होगा. अब 6 महीनों में तो केस नहीं खत्म होगा. So the court in the judgment said कि इन्होंने all they could describe to us is 6 months. What we could easily have said, right, is that we could one just say we're not going to execute until the end of the judgment, or secondly we could have said that this procedure at a minimum it would take 2 years before he can be executed because the writ jurisdiction is a very long drawn out process. This and that.
I even heard Pakistani media reporting that Nawaz Sharif government signed this treaty 10 days prior to when India went to ICJ, which created a legal obligation or something.
No, that was a declaration. We changed our declaration. We didn't sign it.
So what arguments did the lawyer use that we lost?
So we didn't lose it. We were not. It was very difficult to win, right? Because the court's default setting is to give a stay. But we could have just said to them, yeah, we're not going to execute until the end of this case, and we want this case to rush up. जितना जल्दी आप करेंगे, उतने जल्दी हम इसको.
What did they say?
So,
yes, sir. So, if ICJ gives consular access to India, can it somehow stop the execution of Jadhav?
we'll get to that.
If yes, then how, and if no, then
Once we get to that, that's a good question.
So my question is like, जब हमने prove करना है उनको दिया है हम उसको फिर नहीं लेंगे execute. Does the question of credibility come in?
No, once a state gives a statement.
Statement, but I mean states.
When the state gives an assurance to the court,
Right.
the state will abide by that.
The state will abide by the. Are there instances in the past where states have given statements and then they have come the other way?
The US original cases, there was federal government was representing. Federal government is what represents outside of the right? The State Department. They said, we abide by the court's decision and we implement this at home. At home, the states, which are independent of the federation in that sense,
Right.
they said, we're not bound by this. Right? There is nothing in our domestic law or constitution or anything which says that you can bind us by these decisions. And so in all 3 cases, they went and executed all those people. Right?
And just
Pakistan can deny consular access. They are the signatory.
It's not that easy. You can't say, for example, we will still be liable. Like the US is still, its federation is still liable to the international community for failure to abide by international law. But what were the consequences? And when I tell you what the court actually ordered, it wasn't a release of those individuals. We'll get to that. I want to save that as a nice, pleasant surprise for us. Basically, there is really nothing that India can do. Okay? You will still end up hanging this man. Worst case scenario, you'll be hanging him after 2 years. Okay? That's it. So I've given away the surprise. So you have preliminary measures. So if you want to raise a question quickly, because we only have 15 minutes left.
Did Pakistan change the declaration 10 days before India took the case?
March 29th, but it was separate. We had submitted this to the Prime Minister's office a year in advance, much before this entire.
But if we had changed the declaration before the case,
The declaration has nothing to do with this case.
right.
That declaration was the first ground. India brought this case to us again on the second ground. These were the grounds. Okay? Second ground is a separate ground altogether. It was under the treaty optional protocol. I don't know if it's in this, but I'll show you that in a bit. Anyway, so in the second phase, that's what we have. The third phase, jurisdictional phase, or the preliminary objections phase. This is where, sorry, I have to go back to the previous phase. So preliminary measures mean, how does the court determine, you can only give a judgment if you have jurisdiction in a case, right? But by this time, because it's an emergency situation, you don't have time to assess jurisdictional arguments or anything. So the standard that they want is a very low standard. It's called prima facie. Okay? Okay, on the face of it, on the facts that are brought to, I feel that the court has jurisdiction. And that's what India had to prove here. One was urgency, and secondly, the urgency se pehle, they had to prove a very basic standard that yes, the court can hear this. And that was very simple to prove. They showed the optional protocol. A dispute arising as to the interpretation or application of the Vienna Convention will be taken to the ICJ. Court covers this is enough. So that low standard. We can challenge this, and we have very good arguments to challenge this, but we couldn't have done it at this stage. This was too preliminary a stage. So India succeeded on those two grounds, and urgency we demonstrate. In fact, yeah, so that's that. Next phase is the proper jurisdictional phase. Here we bring up our big guns and our big arguments, right? Where we argue in detail why the court, despite what the optional protocol says, we have other grounds for why it shouldn't bring this up. And then there's the merits phase, which is the actual case. Did Pakistan violate the Vienna Convention? Did India have a right under it? Were there any exceptions to it, say under 2008 agreement? That's the final thing. These two stages can be merged because there are arguments at the jurisdictional phase that cannot be determined unless you look at the merits. Okay? For example, the court does not have jurisdiction because under the 2008 agreement, Pakistan has an exception, it doesn't have to give consular access. This argument is a jurisdictional argument, but it discusses everything on the merits. कि 2008 agreement थी क्या उसकी क्या status है, how is it sitting? Unless the 2008 agreement is valid, this jurisdictional argument cannot stand. So we have to first show the validity. That's why you merge these two phases at times. So you can discuss issues of merits which are linked to jurisdictional issues. I'm sorry this is complex and it's annoying, but this is how it's done. So the authority for the court to listen to the case is sometimes tied up with the actual case. So you can't initially tell the court, आप सुन ही नहीं सकते जब तक आप केस की बातें नहीं करेंगे, right? आप समझ आ गई? So केस की आपको बातें करने के लिए और court jurisdiction, getting rid of it, sometimes has to be merged, and that's what happens. Right now, I don't know exactly what the situation is. I think they might have merged it because India has to submit its memorial in September, and then we have to submit our counter memorial in December for this year. Alright, so that's going to be the next phase that's happening.
This is going to be a long case.
Yeah, generally this is going to take about a year and a half, 2 years. नहीं होता है ICU वो वाला RMI वाला केस भी नहीं होता. In fact, longer perhaps 3 years. I look at you too when I do that. So India's reasons for approaching the ICJ. The first one, and this is our assessment again, this is not stuff you find there. It was caught red-handed and reciprocating Pakistan's cooperation in terror-related investigations would be too damaging for India. We've already discussed this, right? If India had given the same type of cooperation, आप हमारे raw chief से मिल लें, उनकी काफी damage होगी, right? It would in essence be an acceptance that yes, we sent a spy, and we're interfering in your country and we're violating international law. Secondly, they had a media frenzy going on. Kulbhushan Jadhav, is mulk ka beta, this and that, Pakistani haathon mein, ye. So this was, they had really no options. They said, we will defend him. The government said, once the government took the decision that we will defend him, and the media was all out for it, they had no choice in this matter. Because if you run out of options, और एक option रहती है, और आप कहते हैं मैं सब कुछ करूँगा इस केस के लिए, तो उस option को भी आपको utilize करना होगा. So the ICJ was the last option that they had, and because they had painted themselves into a corner, they had to do this as well. Secondly, the Modi government, again, its robust foreign policy against Pakistan, it wanted to show that we're not going to bend to Pakistan at all. right? They said, "हम करेंगे intervention और हम we're not going to be sorry about it." And secondly, they want to use this case to delegitimize Pakistan's internal processes. So, for example, military courts का ये जो field general court martial process है, they want to embarrass Pakistan at the international level, saying ये देखो, they don't even have a civilian court system that would deal with this. और यार ये देखो उनका जो military courts से ये सब कुछ कर रहा है, अपना मुल्क सुधार रहा है, right? Military courts is not an ideal solution. It's not a human rights-based solution. It's not a wo solution. It's damaging to your reputation in
That
international.
is happening in Pakistan as well. The military has more and you take care
Absolutely. Absolutely. So it's not the best solution. I think would be for terrorism, for example, you need to fix your anti-terrorism court system. But in this situation, they will just use that. And that's exactly what they've said. It's a farcical process by which they've convicted Kulbhushan Jadhav. That's what the Indians have said in their application to the court. And
To the
farcical
process.
farcical process. They've used that term again and again and again. Okay. Really try to damage and say, yeah, ये देखो एक innocent आदमी को इन्होंने फांसी दे दी है, तो ये दो फौजी बिठा दिए या इस किस्म का.
So why can't Pakistan try and disable it?
We could have.
Can we do it?
Can we do it now? We've already convicted him for something. Could we do it for another offense? Yeah, probably. Terrorism related, all such charges and everything. But the thing is that you need to have evidence to convict an individual, right? So intelligence evidence, this is a huge other story. Maybe we'll discuss it when we discuss counterterrorism next or tomorrow or the day after. But intelligence evidence is not admissible. Intelligence material is not admissible in court unless you get a warrant under a specific law for it. And it's highly unlikely that we do this because Pakistan isn't as efficient as we would like to be.
So legally military courts can try to
Military courts
spies.
can use
Intelligence, evidence.
Best by
They can try.
in some way or form. You'll have a military officer that can give testimony there. They won't question his testimony. Cross-examination limited हो जाती है, stuff like that. So those are issues that are out there.
Especially when it's a field general court martial because it's like wartime, it's just a technique.
So we don't have time to look at his second confession with video. We'll go through that some other, like you can just go to YouTube and find it. But there was one that's been released very recently, in which he's a lot more happier, better fed. But that was also done in April of this year.
That's the second one or is that the third one?
So that has fewer cuts. That's the second one. It has fewer cuts in it, and it's a generally better produced video.
ICJ are increasing their budget.
Exactly. You should have released it as a movie video. But anyway, so what are some of the complications in this case? And when I say complications, these are also opportunities for us. Let's see if we can go through all of these, otherwise we can discuss it over tea or something. Pakistan-India agreement on consular relations. Let's look at this. It's the last thing on page 71. Okay, so we are going to read paragraph, the first preambulatory paragraph, and after that we're going to read 6. Alright, so that's the government of Pakistan and the government of India desirous of furthering the objective of humane treatment of nationals of either country arrested, detained or imprisoned. This is the same language in Article 36 of the Vienna Convention. In the other country have agreed to reciprocal consular facilities as follows. So a bunch of these things, like if we just look at this, there's going to be a comprehensive list that will be maintained of nationals of the other country. Immediate notification. So part of consular access is giving notification to the government that your citizen has been arrested. Okay. Sir? In this case, we did late. Each government undertakes to expeditiously inform the other country of sentences awarded to convicted nationals of the other country. Yes, okay. So now let's go to 6. In case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on its merits. What is the topic? If we go back to the previous video, what is the topic of this agreement? Pakistan-India Agreement on Consular Access. So we can determine if it's on political or security grounds. It is our discretion whether we give consular access or not. Similarly, it is India's discretion if one of ours is arrested on those grounds, to grant or not to grant. So this तो clear cut says कि यार अगर national security issue में कोई पकड़ा जाए तो आपकी मर्जी आप देना चाहिए ना देना चाहिए, हमने कहा हम नहीं देते, right? Simple, straightforward. India signed this with open eyes. They weren't armed to a stint कि नहीं ये करोगे but I will bomb into the Stone Age. We didn't say कि हम तुम्हारा पानी बंद कर देंगे या हम atom bomb फेंक देंगे. कि there was no coercion, there was no undue anything on that.
क्यों ये आर्गुमेंट नहीं दिया पाकिस्तान ने?
अभी वो आएगा टाइम आएगा देने के लिए.
स्टे कैसे हो गया फिर जब when
तो
they had
stay,
signed
as I
this-
mentioned, stay was a very preliminary stage. उसमें you couldn't assess all of these things. ये arguments अभी टाइम हर केस का अपनी phases होते हैं. उस stage में आप कर ही नहीं सकते थे. So we were bound to lose that. So don't worry about that. It's in the next phases we will bring this up. Now the issue is,
सादा अल्फाज में इंडियन को ICJ को सिर्फ ये प्रूव करना कि बहुत अर्जेंसी है, आप स्टे दे दो। पाकिस्तान ये प्रूव नहीं कर सका कि अर्जेंसी नहीं है और स्टे दे दो। ये हुआ।
absolutely. Okay, so we're clear on this, right? Pretty evident.
What's the counter argument that India?
India is saying it's trying to distance itself from this agreement, first of all. Secondly, it's undermining itself by saying this agreement does not sit, is in conflict with the Vienna Convention.
Now the debate is which convention takes precedence.
Exactly. So this
It's all about
entire
precedence.
case is going to be on which treaty takes precedence. Okay. India is saying that the Vienna Convention gives a separate ground. It should be read separately from this agreement. You can't read them together. Sorry?
Who initiated this agreement? Pakistan or India?
We don't have enough on that. Right, Talha? No, this was a mutual thing. I mean, the primary purpose is not for spies. This is for fishermen actually. So, iske niche a joint judicial commission for fishermen and generally other people who are arrested. So, all of these provisions are really nice provisions. Immediate notification, making of lists, they're all good things. It's only that one exception we created, which is not the nicest, which relates to political insecurity. So, we brought in this element to secure both our states. It doesn't apply just one way, it applies reciprocally to both states.
नेशनल फोर्सेस एंड स्टेट्स की अगर इंडियन आर्मी है या पाकिस्तान आर्मी तो कोई ऐसा लॉ या ट्रीटी जो सिर्फ फोर्सेस से रिलेटेड हो, स्पाइस जो आर्मी की तरफ से भेजे गए हों, क्या ये अंडर नेशनल सिक्योरिटी आएंगे या उनका अलग कोई लॉ हो या कोई?
Yes, कल आपने पढ़ा IHL. IHL deals specifically with how you deal with armed forces. IHL में there is that specific provision in times of occupation, if there's a spy that you captured, you can limit him. You don't have to give any consular access to an individual. But that is for times of war. The status of the situation has to be ab jang ki halat mein. Pakistan के लिए नहीं है जंग की हालत में ऐसा.
लेकिन हम स्पाई को इसी तरह इसी कैटेगरी
So we would generally use this category. We can make arguments of IHL. और हम कह सकते हैं by analogy, पाकिस्तान के अंदर terrorism बहुत serious issue है. These Indian government was supporting and promoting that form of terrorism.
Look at the scenario of Balochistan, तो
Absolutely. So we can say by analogy, you should use the IHL provisions of limiting rights of access and communication to this situation because यहाँ पे उसी किस्म की threat है. और ये spy अगर हम देते तो क्या होता है? India को he could have given information of what इसके नेटवर्क है तो उस नेटवर्क कौन सा कॉम्प्रोमाइज हो गया, किसके बारे में मैंने बातें बताई हैं पाकिस्तानियों को, किसके बारे में मैंने नहीं बताई, ठीक है, which are still in play that you can still operate use to engage in further disruptive activity in Pakistan. Okay, so we have the Pakistan-India consular agreement. Let's look at the second ground. This is for the optional protocol. I don't know if you give me the optional protocol. Chalo, let me put it up on the thing. So this is Article 1. I don't know if everyone can read this, but I'll read it out loud. Article 1 of the optional protocol says, disputes arising out of the interpretation or application of the convention shall lie within the compulsory jurisdiction of the International Court of Justice. Sorry?
Discretion is with them.
With who? Discretion, this is another issue that I want to raise here. Disputes arising out of the interpretation or application. So India is saying that there is a dispute here. We are saying, or at least what I am saying, my argument is, there is no dispute.
Right.
Because our interpretation and application is in the 2008 agreement. We both two countries with open eyes and free will decided to sit down and write together what our interpretation